Before we begin, a quick and important disclaimer. The following content is intended strictly for educational and entertainment purposes. It does not constitute legal, financial, or psychological advice. Divorce laws, judicial interpretations, and procedural requirements vary significantly across different states and jurisdictions within the United States. Viewers should conduct their own due diligence and consult with a licensed attorney or a qualified professional regarding their specific circumstances before making any life-altering decisions. Imagine standing at a crossroads where half of the people you know have already walked one path, yet almost none of them can tell you exactly how they got to the other side without losing their shirts, their sanity, or their sense of self. In the United States, we are currently witnessing a statistical anomaly that most social scientists didn't see coming. The evolution of what insiders call Divorce 661. While the national divorce rate has actually stabilized or even slightly dipped for younger generations, the complexity, the cost, and the legal entanglement of the process have reached an all-time fever pitch. We are looking at a landscape where the average contested dissolution now takes over 18 months to resolve, and can easily cost upwards of $15,000 in legal fees alone, even for a middle-class household. But here is the shocking reality that the glossy self-help books won't tell you. The system isn't just broken. It is designed to be a labyrinth that rewards those who understand the unspoken mechanics of the 661 framework and punishes those who walk in with nothing but emotions. By the end of this deep dive masterclass series, you will understand the historical trends that led us here, the case studies of high-stakes splits that changed the law forever, and the precise mechanical breakdown of how modern American domestic relations courts actually operate behind the closed doors of judges' chambers. This video is the definitive retrospective on why the American divorce experience has transformed into its current state. For the US audience, this solves the fundamental problem of information asymmetry. Usually, the only people who truly understand the gears of the court system are the professionals billing you by the hour. We are pulling back the curtain to give you a masterclass in the structural realities of the 661 phenomenon. This isn't about picking sides or emotional venting. It is about the cold, hard data of how assets are divided, how custody is determined in a post-pandemic legal environment, and how the concept of equitable distribution has become one of the most misunderstood phrases in the American lexicon. To understand where we are today, we must first look at the historical trajectory of the American family unit and how the legal system struggled to keep pace. For decades, the 1969 California Family Law Act, signed by then-Governor Ronald Reagan, served as the primary catalyst for the no-fault revolution. Before this, you had to prove grounds, adultery, cruelty, or abandonment. This created a fault-based economy where private investigators were the most important players in a courtroom. However, as we transitioned into the 1980s and 90s, the focus shifted from why a marriage ended to how the remains were distributed. This shift birthed the complexity we see today. In modern case studies, we see that the legal system has moved from a moral arbiter to a giant accounting firm, but one that operates with the emotional volatility of a high-stakes drama. Consider the case of the dual-income, no-kids or dink households that rose to prominence in the early 2000s. When these unions dissolve, the complexity isn't about child support. It's about the valuation of intangible assets. We are talking about the potential outcomes of splitting 401ks, stock options, and even celebrity goodwill or professional degrees. In many jurisdictions, if one spouse supported the other through medical school or an MBA program, the court may view that degree as a marital asset with a future earnings value that must be compensated. This is the 661 mindset. Every sacrifice has a line item value. Furthermore, we have to address the geographical lottery of American divorce. Depending on which side of a state line you reside, your financial future could look drastically different. In community property states like Texas or California, the starting point is often a strict 50-50 split of everything acquired during the marriage. In equitable distribution states like New York or Florida, the court looks at what is fair, which is a subjective term that leaves a massive amount of power in the hands of a single judge. This subjectivity is where the 661 complexity thrives. It creates a vacuum where potential outcomes are no longer predictable, leading to longer litigation and higher emotional tolls. Let's look at the data regarding the silver divorce trend. Over the last 20 years, the divorce rate for Americans over the age of 50 has doubled. These are individuals who have spent 30 or 40 years building a life together. For them, the retrospective isn't about who gets the house. It's about how to survive on a fixed income when the retirement nest egg is suddenly sliced in half. Historical trends show that women in this demographic are particularly vulnerable. often seeing a 45% drop in their standard of living, whereas men may see a smaller decline or even a slight increase over time. This disparity is a central pillar of our investigation into the 661 phenomenon. It raises the question: is the system truly equitable if the long-term outcomes remain so radically different for the parties involved? Step by step, the process has become more digitized and more forensic. In the past, you might hide a few $100s in a shoebox. Today, forensic accountants are tracking cryptocurrency wallets, Venmo histories, and hidden offshore digital accounts. The 661 era is defined by the digital paper trail. We have seen case studies where a single deleted text message or a forgotten LinkedIn post became the smoking gun in a high-asset litigation. The legal system has had to evolve into a tech-savvy entity, with judges now routinely ordering social media discovery, where every photo you've posted for the last 5 years is scrutinized for evidence of dissipation of marital assets. Essentially, spending joint money on things the court doesn't approve of while the marriage is failing. But beyond the finances, we must look at the psychological infrastructure of the U.S. court system. The best interests of the child standard, while noble in theory, has become a battlefield of expert witnesses. We now see a surge in the use of parenting coordinators and guardian ad litems. These are third-party professionals who essentially become the shadow parents, making decisions on where a child spends Christmas or what school they attend when the parents cannot agree. This represents a massive shift in American domestic policy, the outsourcing of parenting to the judicial system. It is a costly, invasive, and often traumatic layer of the 661 experience that many families don't realize they are entering until they are already deep in the system. This deep dive is about more than just a retrospective. It is a roadmap of the shifting sands of American society. We are exploring the tension between the individual's right to leave a contract and the state's interest in maintaining social stability. As we move forward into the subsequent parts of this masterclass, we will break down the specific strategies used by top-tier firms, the common pitfalls that lead to litigation fatigue, and the emerging trends like collaborative divorce that attempt to bypass the 661 trap altogether. This is the reality of the American split in the 21st century. A high-stakes, high-cost, and highly complex transformation that reshapes everything in its path. We are going to examine the granular details of state-specific statutes, the impact of the 2017 Tax Cuts and Jobs Act on alimony, and why the standard of living calculation is the most contested formula in any courtroom today. Get ready, because we are just scratching the surface of the 661 retrospective. The complexity of the American matrimonial landscape shifts dramatically when we examine the actual math behind the standard of living. In the legal corridors of 2026, the term lifestyle analysis has become a weaponized accounting tool. To understand why this matters, we have to look at the transition from the old-world alimony models to the modern 661 framework. Historically, alimony was often a lifelong tether, but today historical trends show a pivot toward rehabilitative maintenance. This is the idea that the lower-earning spouse should only be supported for a specific duration to become self-sufficient. But here is the friction point. How does a court define self-sufficient for someone who has spent 20 years in a high-net-worth household? Imagine a hypothetical case study involving a couple we will call Mark and Sarah, living in a high-cost-of-living area like Northern Virginia or Orange County. Mark is a senior executive at a defense firm, and Sarah left a promising career in architectural design 2 decades ago to manage the household and raise 3 children. When they enter the 661 process in 2026, the court doesn't just look at their current bank balance. They perform a forensic look back at the last 3 to 5 years of their marital life. They look at the country club dues, the frequency of international travel, the private school tuitions, and even the monthly expenditure on high-end organic groceries. The standard of living isn't just a number. It is a baseline that the court uses to determine if Sarah can maintain a reasonably similar lifestyle post-divorce. If the marital lifestyle costs $30,000 a month to maintain, and Mark's post-divorce income is $50,000 a month, the legal argument centers on how much of that gap Mark must bridge. However, the 2017 Tax Cuts and Jobs Act radically altered the math of these potential outcomes. Before the act, alimony was tax-deductible for the payer and taxable income for the recipient. In 2026, we are seeing the full-term consequences of that shift. Alimony is now paid in after-tax dollars. This means Mark is paying with money that has already been taxed at the highest bracket, while Sarah receives it tax-free. On paper, it looks like a win for Sarah, But in reality, it often leads to much more aggressive litigation because the payer feels the financial sting much more acutely than they did a decade ago. Now let's go deeper into the mechanical breakdown of asset division, specifically the distinction between marital and separate property. This is where most Americans lose their footing. Suppose Mark owned a small tech startup before he married Sarah. At the time of the wedding, the company was worth $1 million. 20 years later, it is worth $50 million. In many U.S. jurisdictions, that $49 million increase is considered marital appreciation. Even if Sarah never stepped foot in the office, her contribution to the home is legally viewed as the domestic infrastructure that allowed Mark to focus on the business. The 661 retrospective reveals that the valuation of these businesses has become a battlefield of expert witnesses. Each side hires a forensic accountant. Mark's expert will argue the business's value is lower due to market volatility or keyman dependency. Sarah's expert will argue the value is higher, utilizing the discounted cash flow method to project future earnings. This isn't just a disagreement. It is a strategic maneuver that can cost hundreds of thousands of dollars in expert fees before a single day of trial. This brings us to the concept of the marital waste or dissipation of assets. In 2026, the digital trail makes it nearly impossible to hide the financial footprints of a crumbling marriage. Case studies show an increasing number of claims where one spouse discovers the other has been spending marital funds on a secret lifestyle, whether that be gambling, a secret second family, or luxury gifts for a third party. The court doesn't just get angry, it performs a mathematical clawback. If Mark spent $200,000 of marital funds on a non-marital interest, the court may credit Sarah that full amount during the final distribution. The burden of proof has shifted because of data. In the current year, lawyers are subpoenaing Amazon purchase histories, Uber trip logs, and even Netflix viewing habits to establish timelines of behavior that contradict a spouse's testimony. We also have to analyze the mortgage crisis within the Divorce 661 framework. For decades, the standard procedure was for one spouse to buy out the other's interest in the family home. But in 2026, we are dealing with a unique economic hurdle: the golden handcuffs of low interest rates. Imagine Mark and Sarah have a mortgage at 3% from years ago. If Sarah wants to keep the house, she usually has to refinance to pay Mark his half of the equity. However, the current market rates might be 6 or 7%. Refinancing would double her monthly payment, making the house unaffordable even with alimony. This has led to a rise in deferred sale of residence orders, where the couple remains co-owners for several years until the children graduate, a scenario that keeps them legally and financially tethered long after the emotional bond is severed. This leads us to the most volatile segment of our retrospective: the evolution of custody and the 50-50 presumption. In the early 2000s, many states still leaned toward a primary caregiver model, which historically favored mothers. Fast forward to 2026, and the landscape has shifted toward a statutory presumption that equal shared parenting is in the best interest of the child. While this sounds equitable, the logistical execution is a nightmare for the modern U.S. workforce. How do two parents with high-demand careers manage a week-on, week-off schedule without one of them seeing a significant career stall? The 661 era has introduced the concept of nesting, where the children stay in the family home and the parents rotate in and out. While it provides stability for the children, case studies suggest it often prolongs the conflict between the parents, as they are forced to share a kitchen and a laundry room while trying to build separate lives. It is a high-stakes social experiment playing out in suburban neighborhoods across America. What we are seeing is that the legal system is no longer just a way to end a marriage. It has become a multi-year management phase of a failed corporate merger. The emotional elements are being stripped away in favor of cold, algorithmic distributions. But as the math gets more precise, the human cost seems to rise. We are seeing more people enter the system with the expectation of a clean break, only to find themselves trapped in a web of ongoing judicial oversight, mandatory mediation, and endless forensic audits. If you think the financial and logistical hurdles are the peak of the 661 experience, you haven't seen how the system handles the most intangible asset of all, the future. In our next segment, we are going to look at the terrifying rise of digital custody, where parents are fighting over access to a child's social media presence, and the monetization of kidfluencer accounts. We will also dive into the shadow world of gray divorce, where the stakes aren't just about money, but about the very definition of a life well lived in your 60s and 70s. But first, we have to talk about the one thing that can bankrupt both parties faster than any lawyer: the psychological warfare of the custodial evaluation. You won't believe the length some experts go to determine who is the better parent. The custodial evaluation is often described by those within the 661 framework as the most invasive procedure sanctioned by the American civil court system. In 2026, we have moved far beyond simple home visits. We are now in the era of the comprehensive forensic psychological evaluation. To understand the gravity of this, imagine a family in a suburban high-stakes environment. Let's call the parents David and Elena. They are fighting over a 2-2-3 schedule for their 2 young children. Because they cannot agree on the basic temperament of the other parent, the court appoints a custody evaluator, typically a PhD-level psychologist with specific training in forensic assessment. This process is not a single interview. It is a multi-month investigation that can cost between $10,000 and $50,000, depending on the complexity and the number of experts involved. David and Elena are subjected to a battery of standardized tests, such as the Minnesota Multiphasic Personality Inventory or the Millen Clinical Multiaxial Inventory. These assessments are designed to flag personality traits, potential for conflict, or underlying mental health conditions that might impact parenting. But the 661 retrospective reveals a more complex layer. The evaluator also interviews teachers, pediatricians, neighbors, and even the parents' new romantic partners. This creates a ripple effect of social scrutiny that effectively puts the family's entire existence under a microscope. One of the most controversial elements in 2026 is the use of clinical observation sessions. Imagine David sitting in a small room with a two-way mirror, instructed to play with his children while the evaluator takes notes on his every move. Does he offer too much praise? Is he too permissive? Does he fail to set boundaries when the toddler throws a block? These moments, which would be considered normal parenting stress in any other context, are codified into a formal report that can dictate the next 15 years of his relationship with his children. Historical trends show that these reports carry immense weight. Judges, who are often overwhelmed with backlogs, lean heavily on the evaluator's recommendation as a shortcut to a final order. This leads us into the emerging frontier of digital custody and the monetization of a child's likeness. In the United States, the rise of the kidfluencer has created a legal vacuum that the 661 framework is only now beginning to address. Consider a case study of a couple in 2026 who built a successful YouTube brand around their family life. When the marriage ends, the fight isn't just about who gets the children on weekends. It is about who owns the digital rights to the children's images and who controls the revenue from their social media presence. Courts are now being forced to grapple with questions that didn't exist a decade ago. Is a child's Instagram account a marital asset? Does a parent have a right to post a child's face if the other parent objects on privacy grounds? Potential outcomes in these cases are often messy. Some judges are beginning to issue digital injunctions, preventing either parent from posting the children for commercial gain until they reach the age of majority. This is a radical shift in the concept of parental rights, where the state steps in to protect a child's future digital footprint from the commercial interests of their own parents. It reflects a broader American trend, the recognition that a child's privacy is a tangible asset that can be dissipated just as easily as a bank account. Beyond the digital realm, we must analyze the grueling reality of the vocational evaluation. This is a specific step often triggered when one spouse, like Elena in our hypothetical scenario, has been out of the workforce for several years. The higher-earning spouse, David, may hire a vocational expert to prove that Elena is underemployed. The expert will conduct a multi-hour interview, review Elena's past resumes, and perform a labor market analysis for her specific region in 2026. They will produce a report stating that while Elena claims she can only earn $40,000 a year, her skills and education actually qualify her for a position paying $85,000. The court then uses this data to impute income to Elena. This means the court calculates alimony and child support as if Elena is already making that $85,000, regardless of whether she actually has a job. It is a cold mathematical way of forcing a return to the workforce, and it highlights the transactional nature of modern dissolution. The 661 retrospective shows that for many stay-at-home parents, this is the moment the reality of the post-divorce economy truly hits. The safety net they thought they had built through decades of domestic contribution is replaced by a labor market projection and a requirement to re-enter a professional world that may have passed them by. We also need to discuss the role of the guardian ad litem or GAL. In many high-conflict cases, the court appoints an attorney whose sole job is to represent the best interests of the children. However, the GAL is not the child's lawyer in the traditional sense. They don't have to do what the child wants. Instead, they act as an investigator for the court. In 2026, we see a trend where the GAL's influence can often supersede both parents' wishes. If the GAL decides that a boarding school is better for the child than staying in the local district, their recommendation can become the law of the land. This adds yet another layer of professional fees and another stranger making fundamental life decisions for the family unit. The step-by-step breakdown of a 661 case often leads to what professionals call the mid-litigation wall. This is the point, usually around month 12, where the initial adrenaline has worn off, the legal retainers have been exhausted twice over, and the parties realize that the court system is not going to provide the emotional closure they seek. It is a system designed for the efficient distribution of property and the scheduling of human time, not for the healing of hearts. Historical trends in the U.S. show that this is when the majority of cases finally settle out of court, often on the courthouse steps just minutes before a trial is set to begin. The exhaustion becomes the primary motivator for compromise. But what happens when the compromise fails? What happens when one party decides to engage in what is known as scorched earth litigation? In 2026, this often takes the form of endless motions for contempt, constant challenges to the valuation of assets, and the weaponization of the discovery process. We see case studies where one spouse will demand every single receipt, every email, and every calendar entry for the last decade, simply to drive up the other's legal bills. The 661 framework is particularly susceptible to this because it relies on the cooperation of both parties to be efficient. Without that cooperation, the system becomes a black hole for family wealth. As we look deeper into the retrospective, we see that the American experience of divorce is being fundamentally reshaped by these procedural hurdles. It is no longer a simple exit, it is a specialized industry. If you think the financial audits and the psychological testing are the end of the road, you are mistaken. We are about to enter the most high-stakes territory of all, the division of the future. In the next part, we will explore the 661 approach to the most complex financial instruments in the modern world. From the division of unvested stock options and restricted stock units to the terrifyingly complex world of tax-deferred executive compensation. We will also examine why your choice of state and even your choice of specific county within that state can change your financial destiny by millions of dollars. The geography of the 661 system is the hidden map that determines who survives and who thrives. The geography of American domestic relations is not a unified field. It is a fragmented collection of 50 different experiments in social engineering. To understand the 661 framework in 2026, you must understand the concept of forum shopping. This is the strategic effort to file for dissolution in the jurisdiction that offers the most favorable statutes for your specific financial profile. Imagine a character named Robert, a high-level software architect based in Seattle, Washington, but who owns property in Austin, Texas. Robert's compensation package is heavily weighted toward restricted stock units and unvested options. If the filing occurs in Washington, a community property state, the court traditionally views the portion of those options earned during the marriage as a joint asset to be split down the middle. However, if the case is heard in a different jurisdiction with different vesting interpretations, the timing of the filing could shift millions of dollars from the marital pot back to Robert's separate estate. In 2026, the complexity of these executive compensation packages has reached a level that baffles even seasoned general practice attorneys. We are no longer just looking at a salary and a bonus. We are looking at tiered vesting schedules, performance-based units that may or may not ever materialize, and deferred compensation plans that sit in a tax-advantaged limbo. The 661 retrospective shows that the most critical battle in these cases is the determination of the marital fraction. This is a mathematical formula used to decide how much of a future payout belongs to the ex-spouse. Case studies from the last 3 years show that the specific wording of a qualified domestic relations order can be the difference between a secure retirement and a decade of post-divorce litigation. If the order is not drafted with surgical precision, the plan administrator may reject it, leaving the recipient spouse with a piece of paper that has no legal teeth. Let's look at a step-by-step breakdown of how a 2026 court handles a high-stakes asset like a startup's unvested equity. First, the court must classify the asset. Is it a gift for past service or an incentive for future performance? If it is for future performance, and that performance happens after the date of separation, the earner argues it is separate property. The non-earning spouse, however, will argue that the opportunity to earn those units was a direct result of the marital support system. Historical trends in states like New York and Connecticut show that courts are increasingly willing to use what is called a coverture fraction to split the difference. This involves dividing the months of marriage during the vesting period by the total months of the vesting period. It sounds simple, but when you factor in the 2026 volatility of the tech market, the actual value of that fraction can swing by hundreds of percents in a single fiscal quarter. This financial instability is mirrored in the real estate sector, particularly concerning the transmutation of separate property. Imagine if Robert used an inheritance from his grandmother, clearly separate property, to pay for the down payment on the family home in 2018. Over the next 8 years, he and his spouse used their joint salaries to pay the mortgage. In the 661 framework, that separate inheritance has now been commingled. The court must decide if the inheritance has been transmuted into marital property, or if Robert maintains a premarital credit. In California, this is often handled via a Moore-Marsden calculation, a complex formula that tracks the specific buy-down of the principal and the appreciation of the property's value. If Robert cannot produce a clear paper trail from nearly a decade ago, the court may simply declare the entire house a marital asset, effectively erasing his grandmother's legacy. Beyond the physical assets, we must address the rise of the digital asset audit. By 2026, the average American household has a significant portion of its net worth tied up in digital ecosystems. This includes cryptocurrency, but it also extends to non-fungible tokens, high-value gaming accounts, and even monetized newsletters or Substacks. The 661 retrospective highlights a massive gap in judicial understanding. Many judges are still catching up to the concept of cold storage wallets and decentralized finance. Case studies reveal that tech-savvy spouses are often able to hide significant liquidity in these digital vaults because the opposing counsel doesn't know the right questions to ask during discovery. This has given birth to a new sub-industry of digital forensic divorce consultants who do nothing but track blockchain transactions to ensure that the marital balance sheet is accurate. We also have to consider the impact of the 2026 insurance landscape on the divorce process. As health insurance costs continue to climb, the issue of COBRA coverage and the loss of a spouse's plan has become a primary hurdle in settlement negotiations. In many U.S. households, one spouse is the primary carrier. When the decree is signed, the other spouse is often kicked off the plan within 30 days. For a spouse with a chronic condition or who is midway through a major medical procedure, this isn't just a financial blow. It is a life-altering crisis. We are seeing more 661 settlements include provisions where the higher-earning spouse must pay the COBRA premiums for up to 36 months, or pay for a comparable private policy. This adds yet another monthly line item that can exceed $2,000, further straining the post-divorce budget. The data also points toward a significant shift in how the U.S. legal system views professional licenses and degrees. There was a time when a law or medical degree earned during the marriage was considered a marital asset with a calculable value. While most states have moved away from this, the 661 framework has introduced the concept of enhanced earning capacity. Even if the degree itself isn't split, the spouse who supported the other through school may be entitled to a larger share of other assets or a longer duration of alimony as a form of reimbursement. It is a recognition that time is the most valuable asset of all, and the years spent investing in one spouse's career are years that the other spouse can never get back. As we move through this retrospective, a clear pattern emerges. The American divorce system has become a machine that processes people through a series of increasingly expensive filters. Each filter, the forensic audit, the vocational exam, the psychological evaluation, the digital discovery, is designed to produce a more accurate result, but at the cost of the family's total wealth. It is a paradox of precision. The more we try to make the split perfectly fair, the less there is left to split. In the year 2026, we are seeing the first generation of couples who are opting out of the traditional court system entirely, turning instead to private arbitration and blockchain-verified prenuptial agreements. However, for those already caught in the 661 gears, the struggle is far from over. We have analyzed the assets, the psychology, and the geography, but we have yet to touch on the most volatile element of the American retrospective: the intersection of divorce and the IRS. The tax implications of selling a family home, dividing a 401k through a QDRO, and the potential for a sudden massive capital gains tax bill are the hidden mines in the legal field. In the next part of this deep dive, we are going to break down the specific tax traps that catch 90% of Americans off guard. We will look at why a 50-50 split on paper can actually be a 40-60 split once the government takes its cut. And more importantly, we will examine the rising phenomenon of gray divorce debt, where older Americans are finding that their golden years are being hollowed out by the high cost of starting over at 65. The final bill is coming due, and you won't believe who usually ends up paying it. The intersection of the Internal Revenue Service and the 661 framework is where many American families see their net worth evaporate through simple mathematical oversight. In 2026, the tax code has become so intertwined with domestic relations that a divorce decree is essentially a tax document in disguise. To understand the gravity of this, we must look at the hidden liability of basis. Imagine a character named Susan who is finalizing her dissolution from her husband, James. They have two primary assets of equal current market value: a brokerage account worth $500,000 and the family home with $500,000 in equity. On paper, Susan taking the house and James taking the brokerage account looks like a perfect 50-50 split. However, the retrospective on 2026 cases shows this is a dangerous illusion. Susan's house has a low-cost basis because they bought it 20 years ago. When she eventually sells it, she may face a massive capital gains tax bill on any profit exceeding the $250,000 individual exclusion. James, on the other hand, might have a brokerage account filled with recently purchased stocks with a high basis, meaning his tax hit upon liquidation is minimal. Susan has essentially accepted a $400,000 asset disguised as a $500,000 one. This is why forensic accountants in the 2026 legal landscape now produce tax-affected balance sheets. They calculate the potential outcomes of future tax liabilities for every single asset before the parties sign the dotted line. Without this step-by-step tax analysis, one spouse often ends up subsidizing the other's future tax bill without even knowing it. Historical trends also point toward the devastating impact of the 10% early withdrawal penalty on retirement accounts. In the 661 era, many couples find themselves cash poor but retirement rich. When the legal bills start mounting, there is a strong temptation to dip into a 401k or IRA. If Susan or James withdraws money before age 59 and have to pay for a lawyer, they aren't just losing the money. They are losing the deferred tax growth and hitting themselves with a 10% penalty plus ordinary income tax. This can result in nearly 40 to 50% of the withdrawal going straight to the government. The smarter procedural move, often used in case studies of successful dissolutions, is the use of a Qualified Domestic Relations Order, or QDRO. This allows for a one-time transfer of funds from one spouse's retirement plan to the other's without the 10% penalty, provided the funds stay in a qualified account. But in 2026, many unrepresented litigants miss this window, leading to what economists call the retirement drain of the middle class. Now let's pivot to the escalating crisis of gray divorce debt. By 2026, we are seeing a record number of Americans over 65 entering the 661 process. For this demographic, the retrospective is particularly grim. Imagine Susan and James are now 67. They have spent 40 years building a life, but the emotional cost of staying together has become too high. When they split their assets, they are also splitting their debt, mortgages, car loans, and increasingly parent plus student loans taken out for their children's education. Historical trends show that older divorcees are the fastest growing segment of bankruptcy filers in the United States. The math is unforgiving. If the couple had a combined household income of $100,000, they could manage a $30,000 annual debt service. But when they move into two separate residences, their fixed costs, rent, utilities, insurance, effectively double, while their income remains stagnant. We are seeing case studies where retirees are forced back into the workforce in 2026, not because they want to stay active, but because the 661 split left them with exactly half of a retirement that was only designed to support a single household. This is the phenomenon of the split poverty trap. The standard of living doesn't just drop by half. For many, it falls below the line of sustainability. This leads us to the specific complication of Social Security benefits in the retrospective. For a couple like Susan and James, the length of the marriage is a critical legal threshold. If they were married for at least 10 years, Susan may be entitled to claim benefits based on James's high-earning work record once they both reach retirement age, provided she remains unmarried. In 2026, we are seeing strategic litigation where a spouse will fight to delay the final decree by a few months just to hit that 10-year mark. It is a cynical but effective way to secure a lifelong inflation-adjusted annuity paid for by the federal government rather than the ex-spouse. The complexity of these rules requires a deep dive into the Social Security Administration's procedural manual, a task that many generalist lawyers overlook, potentially costing their clients hundreds of thousands of dollars over a lifetime. Step by step, we must also examine the 2026 reality of the marital debt audit. In the United States, debt is often treated similarly to assets. If James racked up $50,000 in credit card debt on a secret hobby during the marriage, is Susan responsible for half? In community property states, the answer is often a terrifying yes, regardless of whose name is on the card. The 661 framework has introduced the concept of the separate debt defense. Susan's legal team must prove that the debt did not benefit the marital community. This involves a forensic review of years of credit card statements. If that money went to family vacations, she is likely on the hook. If it went to a secret apartment or a third party, she might be shielded. But the cost of proving this distinction often approaches the cost of the debt itself, leading many to simply split the liability and move on. Furthermore, we cannot ignore the role of the 2026 insurance market in these financial collapses. As life expectancy increases, the cost of long-term care insurance has become a major line item in 661 negotiations for older Americans. Who pays the premiums for the policy that was intended to protect both of them from the costs of a nursing home? If the policy is canceled because neither can afford the full premium post-divorce, they lose years of paid-in equity and leave themselves vulnerable to Medicaid spend-down requirements later in life. We are seeing innovative case studies where couples are creating private trusts to hold these insurance policies post-divorce. But the legal and tax complexity of these structures is immense. What we are witnessing in this retrospective is the total financialization of the American family. Every hug, every sacrifice, and every career move is being converted into a spreadsheet of credits and debits. In 2026, the 661 system is no longer a court of equity. It is a court of accounting. But even the best accountants cannot account for the volatility of the human spirit when it feels backed into a corner. As the financial stakes rise, so does the prevalence of what is known as litigation funding. Third-party companies are now lending money to spouses like Susan to fund their legal battles in exchange for a percentage of the final settlement. This introduces a predatory element into the 661 process, where a corporate entity now has a vested interest in the divorce being as expensive and litigious as possible. The final bill for the 661 experience isn't just paid in dollars. It is paid in the erosion of the American dream of a stable old age. But there is a darker side to this financial retrospective that we have yet to explore. While the lawyers and accountants are tallying up the bank accounts, there is a secondary market for information that is being weaponized in the 2026 courtroom. We are talking about the rise of personal data brokers and the use of artificial intelligence to predict a spouse's future earning capacity and spending habits. In the next part of this masterclass, we will dive into the terrifying world of AI-driven litigation and the use of deep data analytics to influence judicial decisions. You will see how your digital footprint from 2024 is being used against you in 2026, and why your private search history might be the most expensive asset you ever owned. The integration of artificial intelligence into the 661 framework by 2026 has transformed the discovery phase of American divorce from a manual search into a predictive science. To understand how this impacts a standard case, imagine a character named Michael, a mid-level manager in Chicago. Michael believes his financial life is an open book, but his spouse's legal team has employed an AI-driven forensic tool that aggregates data from sources Michael hasn't thought about in years. This isn't just about looking at bank statements. It is about the synthesis of a digital persona. The AI analyzes Michael's geolocation history from 2024 and 2025, cross-referencing his Starbucks purchases with his fitness tracker data to build a pattern of life. Historical trends show that by 2026, these high-tech audits are being used to challenge the credibility of testimony in ways that were previously impossible. If Michael testifies that he was working late every Tuesday for 2 years, but his rideshare app data and his smart home thermostat settings suggest he was actually at a different residential address, the AI flags this as a credibility conflict. In the 661 retrospective, we see that the court no longer relies solely on who is the more charming witness. It relies on whose testimony has the fewest digital anomalies. This predictive modeling can even estimate Michael's future career trajectory based on industry-wide data, suggesting that while he earns $100,000 today, he has a 90% statistical probability of earning $200,000 within 3 years. This projection can be used by a judge to adjust alimony durations or amounts, treating Michael's future potential as a present-day asset. Step by step, the use of personal data brokers has become the new frontline. In the United States, your data is a commodity bought and sold by thousands of companies. In a contested 661 proceeding, a legal team can legally purchase a comprehensive data profile of an opposing spouse. This profile includes search histories, app usage, and even sentiment analysis from social media interactions. Imagine if Michael had searched for the best hidden offshore accounts, or how to lower my income for divorce 2 years before the filing. Even if he never acted on those searches, the mere existence of the data creates a narrative of intent that is difficult to scrub. Case studies from 2026 suggest that many litigants are being blindsided by their own past curiosities, as search terms from years ago are presented as evidence of a long-term plan to defraud the marital estate. Furthermore, we must examine the rise of the algorithmic judge. While humans still sit on the bench, many jurisdictions in 2026 are utilizing AI-assisted decision-making tools to manage their massive backlogs. These tools provide the judge with a range of potential outcomes based on thousands of similar cases in that specific county. For someone like Michael, this means his fate may be decided by a mathematical average of what happened to other managers in Chicago over the last decade. While this aims to reduce judicial bias, it often ignores the nuance of the individual human story. If Michael's specific situation has a unique variable that the algorithm isn't programmed to weight heavily, he could find himself on the losing side of a statistical curve. This is the reality of 661. The move toward efficiency is often a move away from individual equity. We also have to look at the terrifying efficiency of deep data analytics in child custody disputes. In 2026, parental fitness is being quantified. There are now apps designed for co-parenting communication that use AI to analyze the tone and frequency of messages. If Michael's messages are flagged as consistently passive-aggressive or non-cooperative by the software's linguistic model, that data is exported directly into a report for the guardian ad litem. The retrospective shows that parents are now performing for the algorithm, carefully crafting their communications to ensure they maintain a high cooperation score. This creates a bizarre environment where the digital record of parenting is flawless, while the actual relationship remains toxic. Case studies involving high-stakes litigation in 2026 also highlight the weaponization of the Internet of Things or IoT. Everything from smart refrigerators to connected cars is a potential witness. We have seen instances where the data from a smart bed was used to prove a spouse's overnight guest policy violation, or where the energy usage spikes in a second home were used to prove that a spouse was living a secret double life. In the 661 framework, the home is no longer a castle. It is a sensor-laden environment that records every movement for potential use in a courtroom. For Michael, this means the very technology he bought to make his life easier has become a 24/7 surveillance network for his legal opposition. This deep data environment has also given rise to a new form of digital gaslighting. We are seeing cases in 2026 where one spouse attempts to manipulate the other's digital footprint to make them appear unstable. This could involve remotely changing smart home settings to cause distress or utilizing deepfake technology to create incriminating audio recordings. While forensic experts can often debunk these fabrications, the cost of doing so is astronomical. The 661 retrospective reveals that the mere accusation of digital instability can lead to temporary restraining orders or the suspension of parenting time, creating a guilty until proven innocent dynamic that can derail a case for months. Let's analyze the broader impact of this on the American legal profession. By 2026, a lawyer who is not tech literate is essentially committing malpractice. The 661 era requires a multidisciplinary approach where the attorney, the data scientist, and the private investigator work in a tight loop. This has created a massive divide in the quality of representation. Those who can afford a tech-integrated legal team have a distinct advantage over those relying on traditional firms. This disparity is creating a two-tiered system of justice where your digital privacy is only as secure as your legal budget. The 661 retrospective also points to a significant change in the concept of discovery. Historically, discovery had an end date. In 2026, discovery is a continuous real-time process. As long as the litigation is active, the data is flowing. If Michael buys a luxury watch 6 months into the process, his spouse's team knows about it almost instantly through credit monitoring and social media scraping. There is no longer a quiet period where you can rebuild your life in private. Every move is scrutinized as a potential shift in the financial or custodial balance. As we conclude this segment on the digital weaponization of the 661 process, it becomes clear that the American divorce experience is now an information war. The battlefield is no longer just the courtroom. It is the cloud, the hard drive, and the algorithm. But while the data tells one story, the human cost of this constant surveillance is beginning to manifest in a new psychological phenomenon known as litigation trauma. In the next part of this masterclass, we will go inside the mind of the 661 litigant. We will explore the mental health crisis currently sweeping through the U.S. domestic relations courts and look at the controversial rise of court-mandated therapy apps. But most importantly, we will address the one question no one wants to ask. Is the 661 system actually making the American family more dangerous? We are going to look at the data on post-separation conflict and the rise of the high-conflict personality as a legal category. You are about to see the human wreckage that remains when the algorithms are done. The rise of the high-conflict personality as a formalized legal category in 2026 marks a turning point in how the United States judicial system manages the human wreckage of the 661 process. To understand this, we must look at a character named Jennifer, a high-performing professional in Seattle who found herself locked in a 3-year litigation cycle. Jennifer's case is a prime example of the high-conflict personality loop. In the modern courtroom, judges are no longer just looking at the facts of the assets. They are looking at the behavioral patterns of the litigants. A high-conflict personality, or HCP, is defined by a preoccupation with blaming others, all-or-nothing thinking, unmanaged emotions, and extreme behaviors. In the 661 retrospective, we see that courts are increasingly utilizing specialized behavioral assessments to identify these traits early, as they are the primary drivers of astronomical legal fees and court backlogs. Imagine the psychological toll on Jennifer, as she is ordered into court-mandated therapy apps. These platforms are not merely for emotional support, they are monitoring tools. The app tracks her engagement, the sentiment of her journaling, and her responsiveness to conflict resolution modules. If Jennifer fails to engage with the app's AI therapist in a way that demonstrates growth, that data is fed back to the court. This creates a high-stakes environment where mental health is no longer a private journey, but a performance for a legal outcome. The 661 framework has essentially weaponized wellness. We are seeing case studies where a spouse's refusal to use a specific meditation app, or their failure to check into a digital co-parenting portal, is cited as evidence of parental alienation or a lack of cooperation. Historical trends show that this level of scrutiny is contributing to a spike in litigation-induced trauma. This isn't just standard stress. It is a clinical phenomenon where the constant surveillance, financial instability, and adversarial nature of the 661 process lead to symptoms resembling post-traumatic stress disorder. For Jennifer, every notification on her phone from her lawyer or the co-parenting app triggers a cortisol spike. By 2026, the American psychological community has begun to recognize the 661 process as a significant social determinant of health. The human cost is staggering. We are seeing a generation of litigants who are so depleted by the time the final decree is signed that they lack the emotional resources to effectively co-parent or even maintain their professional standing. Step by step, the system is attempting to mitigate this through the rise of parent coordinators, or PCs. A PC is a quasi-judicial officer, often a mental health professional or an attorney, who is given the power to make tie-breaking decisions for high-conflict couples like Jennifer and her ex-spouse. If they cannot agree on which weekend the children should attend a soccer tournament, the PC makes the call, and their word is law. However, the retrospective shows that while PCs can reduce the number of times a couple goes before a judge, they add another layer of significant expense. For a middle-class family, paying a PC $300 an hour to argue about extracurricular activities is a fast track to financial insolvency. Let's look at the data on parental alienation, one of the most controversial and litigated topics in the 2026 661 landscape. In the United States, the accusation that one parent is brainwashing the children against the other has become a standard tactical maneuver. The 661 framework handles this through what are known as reunification programs. Imagine Jennifer is accused of alienation. The court may order the children into a high-intensity, multi-day therapeutic retreat designed to repair the bond with the other parent. These programs are incredibly expensive and often involve the children being temporarily removed from Jennifer's care. Case studies show a wide variance in potential outcomes. Some families find a path to healing, while others experience a complete collapse of the family structure, as the children feel caught in the middle of a legal and psychological war zone. Furthermore, we must address the rise of the high-conflict personality as a diagnostic shield. In 2026, Some litigants are using their own diagnosed mental health conditions as a way to explain away non-compliant behavior in court. The 661 retrospective reveals a complex struggle for judges. How do you distinguish between a parent who is genuinely struggling with a condition like borderline personality disorder and one who is simply using high-conflict tactics to win a custodial advantage? The solution has been an increase in court-appointed forensic psychiatrists. These experts perform deep dives into the medical histories of both parents, often requesting records dating back 10 or 20 years. For someone like Jennifer, her entire medical history, including any therapy she sought after a minor life event a decade ago, is suddenly fair game for cross-examination. This leads us to the broader question. Is the 661 system making the American family more dangerous? Post-separation conflict data suggests a disturbing correlation. When the legal process is prolonged, expensive, and hyper-adversarial, the risk of domestic escalation increases. In 2026, we are seeing a rise in what are known as conduct orders. These are highly specific injunctions that go beyond traditional restraining orders. They may forbid a spouse from disparaging the other on social media, from tracking their location via digital AirTags, or even from entering certain neighborhoods. The 661 framework has had to become a policing entity, monitoring the day-to-day behavior of thousands of American citizens who are technically not criminals but are behaving with criminal levels of hostility. Consider the case study of a couple who spent 4 years in the 661 cycle, only to end up in a situation where they are legally forbidden from speaking to each other in person. Their only permitted communication is through a court-monitored text-only app that uses an AI filter to block aggressive language. This is the 2026 reality. The state has become the digital chaperone for the American family. The retrospective shows that while this prevents immediate physical escalation, it does nothing to address the underlying resentment. In fact, many litigants report that the digital oversight makes them feel even more trapped and scrutinized, leading to a phenomenon known as pressure cooker litigation, where the emotional explosion happens once the legal guardrails are eventually removed. We also have to look at the impact on the children who are raised within the 661 ecosystem. In 2026, we are seeing the first cohort of children who have spent their entire lives with their parents' conflict moderated by the state. These children are often subjected to their own set of forensic interviews and psychological assessments. They learn at a young age that their words have legal weight. The 661 retrospective reveals a generation of children who are hyper-aware of their parents' legal strategies, sometimes even being coached on what to say to the guardian ad litem. The long-term psychological data on these children is still being collected, but early indicators suggest higher rates of anxiety and a deep-seated cynicism toward the concept of marriage and the legal system as a whole. As we move through this deep dive, the human wreckage becomes impossible to ignore. The 661 system, for all its technological and procedural advancements, is still grappling with the raw, messy reality of human emotion. We have seen the financial audits, the digital surveillance, and now the psychological warfare. But there is one final frontier in the 661 retrospective that we have yet to uncover. While the U.S. courts are focused on the individuals, there is a massive shift happening in the global landscape of divorce. In the next part of this masterclass, we will look at the rise of international jurisdictional battles and the terrifying complexity of the Hague Convention in the age of remote work. You will see what happens when a spouse takes the children across international borders and why your passport might be the most dangerous document in your house. The 661 framework is no longer just a domestic issue. It is a global crisis of custody. The global reach of the 661 framework in 2026 has transformed the American passport from a symbol of freedom into a primary focus of judicial restraint. In the United States, the rise of the digital nomad and the post-pandemic flexibility of the workforce have created a geopolitical nightmare for domestic relations courts. To understand this, let us look at a character named Thomas, a software engineer in Austin, Texas, who is married to a dual citizen of France and the United States. In a high-conflict 661 proceeding, the court doesn't just look at Thomas's bank account, it looks at his wife's flight history and the status of their children's travel documents. Historically, the Hague Convention on the Civil Aspects of International Child Abduction served as the primary mechanism for returning children taken across borders. However, the retrospective on 2026 reveals that this 1980 treaty is struggling to keep pace with modern technology and the speed of international travel. Case studies now show that a parent can move a child to a non-signatory country within 12 hours, effectively placing them outside the reach of the U.S. legal system. Because of these potential outcomes, we are seeing a massive increase in the use of exit orders. This is a legal directive that prevents a person from leaving a jurisdiction or taking a child out of the country without express court permission. For Thomas, this means that even if he needs to travel for a critical business meeting in London, he may be forced to surrender his passport to his attorney or the court clerk as a condition of his parenting time. Step by step, the International 661 process is an exercise in jurisdictional chess. If Thomas's wife decides to relocate the children to Paris during a summer vacation and refuses to return, the Texas court may issue an order for their immediate return, but the enforcement of that order relies on French authorities and their interpretation of the habitual residence of the children. In 2026, the definition of habitual residence has become incredibly fluid. If the family spent 3 months working remotely from a rental in Provence before the separation, the French court might argue that the children are now integrated into French society, creating a direct conflict with the American ruling. This is where the 661 framework becomes a global crisis. Families find themselves caught between two competing legal systems, each claiming superior authority over the children's lives. We must also analyze the financial implications of international asset tracing in 2026. Thomas might suspect that marital funds have been moved to offshore accounts or invested in foreign real estate. In the past, this would require hiring expensive private investigators in multiple countries. Today, the 661 retrospective shows that legal teams are utilizing international letters rogatory and MLATs, mutual legal assistance treaties, to compel foreign banks to release records. However, this process is glacially slow. By the time the records are obtained, the funds have often been moved through a series of shell companies in jurisdictions like the Seychelles or the Cayman Islands. The data suggests that for every dollar successfully clawed back from an international tax haven, approximately 40 cents is spent on the legal and forensic accounting fees required to find it. Furthermore, we are seeing the rise of the international prenuptial agreement as a defensive tool in 2026. For high-net-worth individuals, a standard U.S. prenuptial agreement may not be enforceable in an EU member state or a Middle Eastern jurisdiction. Case studies from the current year show a trend where couples are signing mirror agreements, identical documents drafted in multiple languages and executed under the laws of each country where they hold significant assets. This is an attempt to create a global shield against the 661 litigation machine, but the cost of drafting these documents can exceed $20,000 before the wedding even takes place. It reflects the American reality of 2026. Love is becoming a cross-border regulatory challenge. Beyond the financial and custodial battles, we have to look at the psychological warfare of international relocation requests, often called move-away cases. In a 661 proceeding, if a parent wants to move with the children to a different country for a job opportunity, the court performs a grueling best interests of the child analysis. Imagine Thomas's wife receives a prestigious job offer in Singapore. The court must weigh the benefits of the career advancement and the cultural exposure for the children against the loss of frequent, in-person contact with Thomas. Historical trends in the U.S. show that these cases are almost never settled. They almost always go to trial because the stakes are binary. One parent wins the move, and the other parent is relegated to a life of FaceTime calls and biannual flights. The 2026 data on these move-away trials highlights a disturbing trend: the emergence of the virtual visitation schedule. Courts are now ordering highly specific digital contact requirements, such as mandatory daily video calls at 6 p.m. Central Time, regardless of the time zone in Singapore. While this is intended to maintain the parental bond, the reality is a logistical nightmare that often leads to further conflict. If Thomas's internet connection drops or if the children are tired and refuse to talk, the other parent is frequently accused of contempt of court. The 661 retrospective reveals that virtual visitation is often a poor substitute for the physical presence of a parent, leading to a gradual but measurable erosion of the relationship over time. We also need to address the role of international tax treaties in the 661 framework. If Thomas and his wife hold assets in both the US and France, the division of those assets can trigger unintended tax consequences in both countries. In 2026, the IRS has increased its scrutiny of foreign asset reporting through the Foreign Account Tax Compliance Act, or FATCA. If a divorce decree orders the sale of a French villa, the capital gains may be taxable in France, while the US might also claim a share under its global taxation policy for citizens and residents. Without a sophisticated international tax expert, The couple could end up paying a combined tax rate of over 60% on the sale, effectively liquidating their children's inheritance to satisfy two different governments. The step-by-step breakdown of an international 661 case often concludes with what is known as the mirror order. To ensure that an American custody agreement is respected abroad, a parent may be required to register that order in the foreign court. This process, known as domestication, is meant to prevent a parent from simply ignoring the U.S. ruling once they land on foreign soil. However, the retrospective shows that domestication is often a toothless process in countries with different cultural values regarding gender roles or parental rights. In some jurisdictions, the local law will always supersede the foreign order if it is deemed to violate the country's public policy. What we are seeing is that the 661 framework has effectively ended the era of the clean break for the modern globalized family. The world has become smaller, but the legal hurdles have become taller. We have explored the digital surveillance, the psychological evaluations, the financial audits, and now the international jurisdictional wars. But as we approach the end of this retrospective, we must face the most uncomfortable reality of all. While we have focused on the mechanics of the system, we have not yet discussed the silent architects of the 661 era, the legislative lobbyists and the multi-billion-dollar divorce industry that benefits from the complexity. In the next part of this masterclass, we will pull back the final curtain on the economics of the 661 machine. We will look at who is actually profiting from your conflict and why the system is structurally resistant to simplification. You are about to see the money trail that keeps the 661 engine running, and why for many the only way to win is to never enter the system at all. To understand the structural resistance to simplifying the 661 framework, we must analyze the economic ecosystem that has blossomed around American domestic relations. In the United States in 2026, divorce is no longer just a legal process. It is a multi-billion-dollar industry with its own lobbyists, service providers, and vested interests. Imagine a character named Gregory, a mid-tier entrepreneur in Ohio. When Gregory enters the system, he sees a judge and a lawyer. What he doesn't see are the hundreds of auxiliary professionals whose business models depend entirely on the perpetuation of conflict and complexity. This includes court reporters, process servers, forensic digital analysts, supervised visitation centers, and the manufacturers of specialized legal software. The retrospective on 2026 shows that the billable hour remains the primary driver of this resistance. When a case is simplified or settled quickly, the revenue stream for these entities dries up. Historical trends indicate that as mediation and collaborative law have gained popularity, the traditional litigation sector has responded by making the procedural requirements of the court more rigorous. For Gregory, this means that even if he and his spouse agree on everything, the court may still require a formal social study, a comprehensive financial disclosure under penalty of perjury, and a series of mandatory status conferences. These steps are often framed as consumer protection, but in practice they function as a toll road that every family must pay to exit their marriage. Step by step, the economics of the 661 machine are reinforced by legislative inertia. In many U.S. states, the statutes governing domestic relations have not been fundamentally overhauled in decades. Why? Because the bar associations and judicial committees that advise the legislature are composed of the very professionals who benefit from the status quo. Case studies of reform efforts in states like Florida or Illinois show that whenever a bill is introduced to make alimony more predictable, or to create a strict formula for asset division, it is met with intense lobbying from groups arguing that such moves would strip judges of their necessary discretion. While discretion sounds like a benefit, in the 661 framework, it creates the unpredictability that fuels further litigation. If Gregory cannot predict what a judge will do, he is forced to keep paying his lawyer to prepare for every possible outcome. We must also look at the rise of the divorce tech stack. By 2026, legal firms are utilizing high-cost subscription software that automates the generation of motions and discovery requests. While this should theoretically lower the cost for the consumer, historical trends show the opposite. Firms often pass these technology fees directly to the client while still billing for the time it takes an associate to oversee the automation. Furthermore, the 661 retrospective reveals the emergence of litigation funding firms. These are private equity groups that provide cash to a lower-earning spouse to fund their legal battle in exchange for a percentage of the final settlement. This introduces a profit-driven third party into the marriage dissolution. These funders are not looking for a fair or fast resolution. They are looking for the highest possible return on their investment. This means they are incentivized to push for aggressive, high-stakes trials rather than quiet settlements. Imagine the scenario where Gregory's spouse is being funded by such a firm. Every settlement offer Gregory makes is viewed not through the lens of family stability, but through a corporate profit and loss statement. If the funding firm believes they can squeeze another $100,000 out of Gregory by dragging the case on for another year, they will encourage the litigation to continue. This is the dark underbelly of the 2026 retrospective, the commodification of domestic conflict. The data suggests that cases involving third-party funding last 40% longer and result in 60% higher legal fees than self-funded cases. Beyond the lawyers and funders, we must analyze the institutional economics of the court system itself. In 2026, many family courts are self-funded through filing fees and court costs. A system that is efficient and moves people through quickly might actually face budget shortfalls. This creates a systemic disincentive for radical simplification. We see case studies where pilot programs for simplified, no lawyer-needed divorce tracks are launched with great fanfare, but are eventually starved of resources or buried under so much red tape that they become unusable for the average person. The 661 framework is a self-preserving organism that views simplicity as a threat to its survival. This leads us to the psychological economics of the 661 machine. The system is designed to trigger the sunk cost fallacy. By the time Gregory has spent $50,000 on his case, he feels he cannot quit or settle for less than his maximum demand, because doing so would mean he wasted that $50,000. The professionals within the system understand this phenomenon perfectly. They know that once a litigant is past a certain financial threshold, they are likely to continue to the bitter end. The retrospective shows that the 661 process is structured to keep you just hopeful enough to keep paying, but just frustrated enough to keep fighting. Furthermore, we must address the role of the media and the cultural narrative in the United States. Viral stories of massive celebrity settlements or high-drama custody battles create a warped expectation for the public. Gregory enters the courtroom expecting a cinematic showdown where he is vindicated. Instead, he finds a sterile bureaucratic process that treats his life like a series of line items. But the industry thrives on that initial hope of vindication. The 661 machine markets itself as a quest for justice, but it functions as a transfer of wealth from the middle-class family unit to the professional class. The data on post-divorce wealth in 2026 is sobering. For every dollar of marital net worth, an average of 15 to 25 cents is consumed by the process itself. For a family with $1 million in assets, that is $200,000 that could have gone to their children's education or their own retirement. When you multiply this by the hundreds of thousands of filings each year, you begin to see the scale of the wealth transfer. The 661 retrospective is, at its core, a study in the unintended consequences of an adversarial legal system applied to an intimate relationship. What we are witnessing is the total professionalization of the end of love. In the 2026 landscape, the idea of a couple sitting at a kitchen table and deciding how to split their lives is becoming an anomaly. The 661 framework has created a social expectation that you need an army of experts to navigate the exit. But as we have seen, the experts are the ones building the maze. The money trail leads to a singular conclusion. The system isn't failing. It is working exactly as intended for those who run it. We have now explored the assets, the digital surveillance, the international wars, and the predatory economics of the 661 era. But there is one final piece of the puzzle that we haven't touched. It is the most radical shift in the entire retrospective, and it is happening outside the courtroom. We are talking about the rise of the exit contracts and the new American movement toward privatizing family law entirely. In our final part, we will look at how the 661 system might finally collapse under its own weight and what the future of American relationships looks like in a post-litigation world. We will examine the emerging case studies of decentralized, blockchain-governed unions, and the return to community-based mediation. But most importantly, we will answer the question, how do you protect yourself from the machine before it starts? The final part of this masterclass is the most important one you will ever watch. The potential outcomes of the 661 framework have reached a critical mass in 2026, leading to a radical movement toward the privatization of family law. To understand the future, we must look at a character named Alex, a tech consultant in Colorado who is entering a relationship in this high-stakes legal environment. Alex has watched the historical trends of the last decade and has decided that the only way to win the 661 game is to opt out of the state-run machine before it even begins. This is not about a lack of trust. It is about risk management in an era where the legal system has become a multi-billion-dollar extraction engine. Alex represents a growing segment of the U.S. population, utilizing smart prenuptial agreements. These are not the static paper documents of 1990. They are living blockchain-governed contracts that utilize decentralized finance protocols to handle asset division in real time. In this case study, Alex and his partner agree to a self-executing sunset clause. If the relationship ends, a pre-negotiated percentage of their joint digital assets is automatically distributed to separate wallets based on the duration of the union. This removes the need for a 3-year forensic audit because the transparency is built into the ledger. This is the 2026 retrospective on the end of the adversarial era, the move from reactive litigation to proactive architecture. Step by step, the 661 machine is being bypassed by the rise of private arbitration and community-based mediation models. In the United States, we are seeing a shift toward what is known as the collaborative pod. Instead of 2 lawyers fighting in a courtroom, a couple like Alex and his partner hire a neutral financial planner, a child specialist, and a single legal facilitator. The data from 2026 suggests that these collaborative models reduce the time spent in the dissolution process by 70% and preserve nearly 90% of the family's total wealth compared to traditional litigation. The historical trends show that as the public becomes more aware of the predatory economics we discussed in the last segment, the demand for these private alternatives is skyrocketing. Imagine a scenario where the court is no longer a room with a judge, but a digital interface where most procedural issues are handled by an agreed-upon algorithm. We are seeing case studies in jurisdictions like Utah and Arizona where simple, uncontested dissolutions are now processed through an automated system that checks for statutory compliance and issues a decree within 48 hours. This is the death knell for the mid-tier divorce industry. The 661 retrospective reveals that the complexity was often a choice made by the system, not a necessity of the law. When given the option to simplify, the American public is choosing the path of least resistance every single time. Furthermore, we must analyze the emerging concept of the social marriage contract. In 2026, some communities are experimenting with 5-year renewable marriage licenses. Instead of a lifelong contract that requires a traumatic legal action to exit, the union simply expires unless both parties actively choose to renew it. This shifts the psychological burden from how do I get out to do I want to stay in? Historical trends indicate that this model reduces the high-conflict escalation often seen in traditional filings because the exit path is clearly defined and pre-negotiated. For Alex, this means the relationship is built on a series of conscious choices rather than a legally enforced status quo. But what about the children? The 2026 retrospective shows that the most successful custodial outcomes are coming from parents who utilize private parenting coordinators from day one. By removing the child custody battle from the courtroom and placing it in the hands of developmental psychologists who operate outside the legal billing structure, families are avoiding the litigation trauma that has plagued the 661 era. We are seeing the rise of the nested parenting model supported by private insurance products that cover the costs of maintaining a family home specifically for the children, while the parents cycle through smaller, separate residences. This is a high-cost solution, but for the American middle class, it is increasingly seen as cheaper than a decade of custodial litigation. The data also points toward a new era of digital privacy protection. In 2026, couples are entering marriages with digital prenups that specify how their data can be used in the event of a split. These agreements include strict non-disparagement clauses and prohibitions on using geolocation or IoT data as evidence in any future proceeding. This is a direct response to the surveillance state of the early 2020s. By contractually agreeing to keep the digital footprint out of the courtroom, couples are re-establishing a zone of privacy that the 661 framework had previously obliterated. Let us look at the potential outcomes for those who find themselves already stuck in the 661 gears. As we move toward 2027, the retrospective suggests that the most effective strategy for survival is radical transparency. By voluntarily providing all financial data in a searchable digital format early in the process, litigants can bypass the most expensive phase of discovery. We are seeing case studies where one spouse's refusal to play the traditional legal games of hide and seek forces the other spouse's team to settle, as there is no conflict left to bill for. It is a form of financial pacifism that is proving to be the most potent weapon against the 661 machine. The retrospective on Divorce 661 in the USA is ultimately a story of an industry that flew too close to the sun. By making the process so expensive, so invasive, and so traumatic, the system forced the American public to innovate. In 2026, we are standing at the beginning of the post-661 era. The machine is still there, and it is still dangerous, but for the first time in 50 years, it is no longer the only option. We have moved from a society that viewed divorce as a moral failure to a society that viewed it as a financial transaction, and finally to a society that views it as a manageable life transition. As we conclude this deep dive masterclass, remember that the most important asset you own in a 661 environment is not your house or your 401k. It is your agency. The system relies on your fear, your anger, and your lack of information to fuel its revenue. By understanding the mechanics of the forensic audit, the psychology of the high-conflict personality, the geography of the court system, and the economics of the industry, you have effectively de-weaponized the process. You are no longer a victim of the 661 machine. You are an informed actor in a complex landscape. The final lesson of the 661 retrospective is simple. The best way to protect yourself from the machine is to build your own guardrails. Whether through smart contracts, collaborative pods, or radical transparency, the future of the American family is being rewritten by those who refuse to be processed. The era of the deep dive is just beginning. And while this masterclass series ends here, the evolution of the American Union continues. The data is clear, the case studies are in, and the historical trends point toward a future where the exit is as respected as the entrance. The story of 661 is a warning, but it is also a blueprint. For every family lost to the gears of the court, another is finding a way to navigate the split with dignity and wealth intact. We have seen the worst of the system, but in doing so, we have discovered the path to something better. The retrospective is complete, but the application of these lessons starts now. If you found this deep dive valuable, the exploration of the American social contract doesn't stop here. In our upcoming investigation, we will look at the rise of the corporate-sponsored household and the new legal frontier of professionalized friendship. You won't believe how the concept of the family is being redefined in the suburbs of 2027.